Welcome to uh, the second part of Module 7 on the subject of mortgages. In this part, we look at two particular aspects. Firstly, we look at the usual covenants in mortgages and say something about the difference between express and implied covenants. And secondly, we look at a number of rights of a torrent system mortgagor, that is the borrower, who remains the owner of the property throughout the currency of the mortgage, which of course is only a charge on the land. The references in the PowerPoints in brackets are references to the set text, Wallace, Weir and McCrimmon, and the references to the clauses in this part are references to the mortgage document on the CMD on the Blackboard site. Now, these are the covenants that we will be considering in this part. They are not the only covenants, as you will see in the mortgage document, but they are important covenants. But firstly, let us look at now, covenants in mortgages might be express or implied. You can see an example of a situation where most of the covenants are express when you look at a copy of a mortgage on the Blackboard site. And from a practical point of view, most mortgages have fully express covenants, and these are registered in the titles office when the mortgage becomes registered. However, it might be possible for a situation to occur where covenants in the mortgage is implied. Now, this might happen when the mortgage remains informal and is not registered. It is possible to charge one's land by simply having sufficient writing and signing that. So if I borrowed $1,000 off you on the security of my property that I owned, that I say called Whiteacre, I could write you a letter simply saying, I, with my name, hereby charge my property Whiteacre with the repayment of a loan made by you to me of $1,000 and then give my signature. That would be sufficient writing to satisfy the statute of frauds and create a charge over the land, an equitable charge, obviously. But all other terms in the mortgage would have to be implied, and you can see them there in Section 78 of the Property Law Act. They're implied covenants to repay the principal and interest as agreed, to maintain buildings on the land, if there were any, and allow you to enter and inspect. There are other implied terms in sections 83, 86 and 87 of the Property Law Act. And section 83 and 84 deals with exercising power of sale. Those covenants would be implied as well if they were not expressed in the mortgage. So there may be some occasion where implied covenants become relevant, and you would have to turn to the particular statute, and whether it's the Property Law Act or below the Land Title Act, to determine whether you could take action against me for a breach of those covenants or exercise the powers given by those implied covenants. However, as I said, it is not common to have this situation, and in most mortgages, all these powers are express, and they are the powers that are followed by the parties. Covenants mortgages may be incorporated as standard term documents under the Land Title Act. The reason for that is, for example, if the Commonwealth Bank mortgages, they don't register a set of standard covenants for home loans. They register one set of covenants and just register mortgages. That's the first page of the document in the CMD, and they refer by a dealing number to a particular covenants or list of document to which it refers. That document is pre-registered in the titles office. So you don't have to, in the case of standard documents that are used hundreds, indeed thousands of times if it's a bank, to register a set of covenants every time with the mortgage. So the Land Title Act at least gives you that facility. Now, a charging clause is essential to create a security over the land. Unless the land is charged with the repayment of the principal and interest, you really don't have a mortgage. You have an ordinary contract of loan. And as you can see there, a charging clause, particularly item 6 in Form 2 under the Land Title Act, will have some specific information in it. The amount of the loan, the period in which the loan has to be paid, and the instalments, monthly or quarterly or whatever they are. So charging clause is essential. Secondly, there has to be a personal covenant to repay the principal and interest. This again is essential to create a mortgage. If there's no covenant to repay the principal and interest, it's not a question of it being repaid within a reasonable time. It may well be that it's not repayable. And in fact, it's not really a mortgage. Usually, all these covenants, charging and personal covenants, will be expressed in the mortgage. But in an informal mortgage, they may be implied by reference to a statute. Just note that the mortgage instrument, once registered, takes effect as a deed, creating a specialty obligation, and that simply means that you have 12 years from the date of the debt or acknowledgement of the debt to repay it, instead of 6 years for an ordinary loan under the statute of limitations. When I say an ordinary loan, I mean an ordinary contract of loan rather than a deed. So in all circumstances, if you mortgage land, it's best to register your mortgage and have as much detail in the operative provisions as possible. The other clause which we should look at, that's clause 7.2 in the Blackboard mortgage, is acceleration of payment. Now, these clauses are very common in land mortgages. It says upon default, effectively, the whole of the money becomes immediately repayable. Now, if that's the case, and normally a mortgagee will then take steps, if it's not repaid within 30 days, to exercise the power of sale and sell the land. They're not going to necessarily sue the mortgagor in the court for the whole of the debt. They will use the security as a vehicle to sell the land and claim the proceeds to pay out the debt. However, the Property Law Act, Section 95, gives a mortgagor relief against this obligation if they make good the default. And making good the default is not paying the whole of the sum owing, but merely tendering or paying that instalment or those instalments which are in arrears. And if that's done, then the effect of the acceleration clause is nullified. And of course, if someone does that, so a mortgagor does that, and the mortgagee does not accept it, the court can make orders that relief be given to the mortgagor and on such conditions as it thinks fit. So have a look at Section 95 of the Property Law Act, as it's a very common clause in a mortgage to accelerate repayment. We are now going to look at the rights of a Torrens mortgagor. We're only concentrating on the more important rights about which there are practical problems, although you will see other rights set out in the mortgage itself. These rights that we're going to deal with are important, and we will look more carefully at the right to redeem the secured property, and in doing so we will examine the concept of clogs on the equity of redemption, that is, obstructions in the way of paying off the mortgage. Okay, well, firstly, let's look at the right to possess land. The mortgagor is the legal owner of the land and entitled to a possession of it. So the mortgagee has no right to possession except upon default, and that right is normally contained in the mortgage itself, or if there is no right in the mortgage itself and it is a proper land mortgage, in other words, the land is properly charged, then Section 78 of the Land Title Act gives a mortgagee under a registered mortgage the right to possession on default in those circumstances. The right to possession can mean actual physical possession, that is, actually entering the property and if necessary, ejecting the mortgagor, or if there is a property subject to a lease, the mortgagee may constructively enter possession by receiving rent or profits, but mainly rent in practical terms, directly from the tenant, which of course goes against repayment of the mortgage. You will see this right in clause 1B, 8.1b of the precedent mortgage in the CMD. So the right to possess the land really is an obvious one, as the mortgage remains a charge. The second one is the right to possess the certificate of title. This is a right of the mortgagee where there is a certificate of title in paper form. Normally that would be held by the mortgagee until the loan is repaid, and as I said, it is more unusual to have this in these days because most titles now remain electronic and the title remains electronic, so there's nothing that the mortgagee has to actually physically possess. But there is a right to get a paper title, and if there is a paper title subject to mortgage, the mortgagee will hold that paper title for the currency of the loan. There is a right of a mortgagor to grant second and subsequent mortgages. That is, that there cannot be a provision in one mortgage, a prior mortgage, if you like, which prevents a mortgagor from granting further mortgages. And if a mortgagee tries to prevent that, then that mortgagee can be restrained, and the court, after an application is made, can require the first mortgagee to show cause why they should not permit it. Now, this was probably more important where there is a paper title being held by the first registered mortgagee. This came into the Property Law Act when that first registered mortgagee refused to produce that paper title for the registration of a second or subsequent mortgage. So now that is not possible, and of course, if there isn't a paper title, any clause in the first mortgage preventing the granting by the mortgagor of a second or subsequent mortgage would not be valid and could be ignored, and of course would not constitute a default if it occurred. So Section 80 of the Property Law Act sets out those provisions. There is also power of a mortgagor to lease the land. As the mortgagor has physical possession of the land, of course, they may lease it to another person after the mortgage has been registered. Well, the mortgagee must consent to that lease of land, and if the mortgagee does not consent to the lease before its registration, that is, the lease does not bind that mortgagee. The effect of that is that if the mortgagee does not consent under Section 66 of the Land Title Act in relation to registered mortgages, and the mortgagee wants to later go into possession, you have a contest between the mortgagee wanting possession and the lessee. Well, if the mortgagee hasn't consented to the lease, the lessee may well be ejected by the mortgagee, as the mortgagee's rights would take priority. Where the mortgagee consents to the lease, then the mortgagee is stopped from denying the existence of the lease and must deal with the land, for example, sell it, subject to that lease interest. This includes both registered and unregistered leases. Where a mortgage is executed after a lease, then the mortgage would take subject to the lease because the lease would have precedence. So that's quite an important practical issue, and solicitors acting for lessees of mortgaged land or ready mortgaged land must be very careful to ensure that the lease gets consent of the mortgagee, or it might place the lessee later down the track if the mortgagor stroke lessor defaults in a very difficult position, particularly if the mortgagee wants to take possession. The right to redeem a mortgage arises in a number of circumstances. One particular circumstance is when the court has to examine a transaction in front of it to determine whether it is in fact a sale of what might be the secured property, or whether it is in fact a mortgage. This occurs where the particular transaction under review appears at first glance to be a sale, but when the substance of it is examined more carefully, it is in fact a mortgage. Obviously, if the transaction is a sale, then the transferee, the person getting the benefit of the property, has an absolute title and it cannot be retransferred back to the transferor. If in fact the property is transferred to another person by way of security, then the borrower, the transferor, has a right to have it retransferred after the loan or whatever is paid off. Thus, that person is said to have a right to redeem the property at that stage. Now, you will see in the first workshop exactly in Module 7 exactly what the position is, because there is an example of this particular issue where you have to decide whether the transaction in front of you is a sale properly so called, in which there's no right to redeem because it's not a mortgage, or whether it is truly a mortgage. So that is the first question before you really get down to the particular problem, as whether there is if it is a true mortgage, is there a clog on the equity of redemption which in any way prevents the mortgagor from redeeming the property or hinders the mortgagor from redeeming the property, in which case it might be void. If one considers this particular concept, the maxim at the top of the slide there, once a mortgage, always a mortgage, refers to the transaction. And if it is a transaction which is held to be a mortgage, the person who transferred the property to the transferee will be entitled to get it back, redeem the property once any loan is repaid. So obviously in these transactions there is a borrower and a lender, or two parties that can be identified as a borrower and a lender. Sometimes the transactions are very difficult to determine one from the other, and the courts in some cases have found that some transactions are effectively equivocal, and found 2 or 3 judges out of an appeal court have found the transaction to be a sale, an absolute sale, although there was a loan of money involved, and the minority have found it to be a mortgage. So sometimes it's not exactly clear. You will see in the first workshop question in Module 7 what I am saying here. Now, the question of equity of redemption becomes important in 3 main circumstances. Firstly, where the equity of redemption is totally extinguished. That is, where, for example, the transaction is set up so that if there is a default in the repayment of money, the lender gets the property or has an opportunity to take the property. The best example of this is the option to purchase, and I will deal with the case of Sun North Developments and Dale in the next slide. The second one is postponing the right to redeem. Now, this isn't a case where the right to redeem is extinguished, but it's a case where the right to redeem is delayed for what would seem a very lengthy period. In other words, the mortgagor could not pay out the mortgage for a particularly lengthy period. Now, as we will see, it's not a matter of whether it's a reasonable or unreasonable period. It's a question of whether the period for redemption is so long, it is illusory, and it would be unconscionable not to permit the mortgagor to redeem. The third case, and probably the most common, is where the mortgagee seeks a collateral advantage from the mortgagor during the currency of the loan. Now, to give you an example of this, and there are a number of examples, there are a group of cases around the turn of the 20th century, and a lot of them had to do with breweries lending to the owners of hotels. And what the mortgage said was simply this, that the brewers would lend the money to the hoteliers, but the hoteliers had to purchase beer from the brewers for the period of the loan. Now, that was one thing, that's a collateral advantage of the mortgagee. But of course, where things got out of hand was, for example, where that collateral advantage went beyond the period of the loan. And in that case, it was seen to be a fetter on the equity of redemption. And we will look at a couple of cases like that. I mentioned in the last slide that where there was an option to purchase granted to a mortgagee, that could amount to what's called the extinguishment of the right to redeem, if the transaction is in substance a mortgage. So where, first of all, you identify the transaction as being a mortgage, you then look at the rights of the mortgagee upon default, and generally, not invariably, but generally, if they give the mortgagee a right to the property, and normally this could be by option to purchase, but it may be by some other means, then that would be seen as a total extinguishment of the right to redeem, because there would be no way that the mortgagor could ever retrieve their property once the loan was paid. A very good example is Sun North Developments and Dale, which is a recent Queensland decision. Here, the borrower owned 40% of the shares in the company in a business of real estate development. The borrower entered into a loan agreement with the lender, whereby the lender agreed to lend $500,000 on a condition of giving a fixed charge over the shares in the company and with an option to purchase those shares. Now, this is important because the option to purchase the shares was integral to the mortgage transaction. And this was so, notwithstanding the transaction was recorded in two separate documents. So the court read both documents together. The value of the shares doubled and the borrower fell into arrears. The mortgagee sought to recover these arrears by exercising the option. And of course, if the value of the shares doubled, you see on the slide there that the mortgagee would get a benefit of the uptake in value. Now, the court found that the loan agreement and the option to purchase were part of the same transaction. In other words, the option to purchase was integral to the mortgage. And in that case, the option was held to be void because it was truly just a mortgage transaction, and the option was a total fetter on the equity of redemption. Now, you'll recall that one of the clogs on the equity of redemption was the postponement of the right to redeem. And this simply means that the transaction is set up in such a way that the mortgagor cannot redeem their property for a lengthy period of time, even if they had the money and tendered it to the mortgagee. So if the postponement is for a very long period, the right to redeem is said to be illusory, and that is what's called a fetter on the right to redeem and will be struck down by the courts. The test for this was set out in the case of Knightsbridge Estates Trust and Burn. Here, the right to redeem the mortgaged property on a payment of principal, interest and costs appeared to be postponed for a period of 40 years from the commencement of the loan. Now, the court looked at a number of circumstances and said that the test was not really whether the right was postponed for an unreasonable length of time, but to be properly described as a clog on the equity of redemption, it must be seen that the postponement is really oppressive and unconscionable to the mortgagor, which I suppose is a higher test than just merely being unreasonable. The thing I would say about Knightsbridge Estates Trust and Burn is that in 1939, a long-term loan of 40 years at low interest may well not have been held to be a postponement on the right to redeem, which would be struck down. But in this modern day and age, where capital is readily available, or money for loan is readily available, depending upon the nature of the loan, a 40-year postponement would, I think, be held to be oppressive and unconscionable. For example, if you took out a house loan with a bank and you couldn't repay it for 40 years, I would have thought in those circumstances in the modern day that it would be held to be a postponement of the right to redeem. Now, if you look at Fairclough and Swan Brewery, the opposite was held, and don't forget this case was 1912. Here, a clause in a mortgage instrument by the lessee of a hotel to a brewery company precluded a lessee from redeeming the mortgage for the whole of the residue of the term of a lease, less a few weeks, being a period of more than 17 years. And further, as a collateral stipulation, precluded the lessee from purchasing beer during the period of the mortgage from any person other than the mortgagee. Here, the Privy Council held that this was effectively a clog on the equity of redemption, which made it void, because the mortgage of the lease fell to be discharged only at a time when the lease itself was on the point of expiry, and when the redemption at that time could be of little value to the mortgagor. This, taken with the trade tie, was held to be oppressive and unconscionable postponement, and was, as I said, held to be void. The third type of clog is collateral advantage, and we have already spoken of this and seen it come into play in the previous case of Fairclough and Swan Brewery. A collateral advantage now as part of a mortgage transaction may offend the Competition and Consumer Act in relation to exclusive dealing. However, let us put that aside for the time being and look at the common law, as the common law would still apply to any proper mortgage. The principal case on collateral advantage is Krieglinker and New Patagonia Meat and Storage Co. Limited. In this case, a loan agreement for 5 years provided from the date of the mortgage that the mortgagor could not sell sheepskins to any person other than the lenders, so long as the lenders were willing to buy at the best price offered by any other person. The loan agreement further provided that the company should pay to the lenders a commission on all sheepskins sold by the company to any other person. So effectively, the meat company was tied up for a period of the loan. However, once the loan had been paid off, the lenders claimed to continue to exercise that right of preemption, which of course was a valuable benefit. Now here, as opposed to the previous case considered, the House of Lords thought that the bargain consisted of two contracts and separated the contract of loan from the contract of preemption, right to buy the sheepskins, which they said was outside the mortgage instrument and which it did not in substance diminish the mortgagor's right of redemption. In reaching that conclusion, the House of Lords distinguished an earlier case, seen on the PowerPoints to come, of Bradley and Carrot, where it was decided that the mortgagor of shares in a tea company, who had covenanted that he would use his best endeavours to secure the sale of the company's tea to the mortgagee after the redemption, had been permanently fettered in the free disposition and enjoyment of those shares. Such an arrangement in that case, the court held, was a contrivance designed to impede the redemption and was struck down by the House of Lords. So you have a situation, firstly, you have to look at whether the collateral benefit is integral to the actual agreement for loan, whether it prevents the redemption of the mortgage unless certain conditions are met, which are unconscionable, or the extent to which the mortgagor is bound under the loan agreement to continue the collateral arrangement with the mortgagee for a period after the actual redemption of the loan. So, to render a bargain invalid, the substance of the bargain must be examined, whether it's one transaction or effectively two transactions. The stipulation which survives, if it does survive and is enforceable, must not be part of the terms of the mortgage and have the effect of cutting down the right of redemption. So where you determine that it's part of the mortgage, then it will be cut down. Now, some of these cases are difficult, and it's merely a matter of setting out your views on those points. This slide summarises the principal points, which I won't read, but you'll get the opportunity when you look at some of the cases in more detail to gain some understanding of the principles. Sometimes the principles appear difficult to apply, but there are situations in these cases where different judges come out with different results. So simply know the principles and apply them. The result isn't as important. Now, here's some examples. The three you've got to know really are the option to purchase, which is usually, if it's a mortgage, an option to purchase, the option to purchase will generally be invalid. Postponing the right to redeem, again, you've got to look at the extent to which it is postponed, that is the time that it's postponed for, whether it's illusory or whether it's real. And you've got to look at the nature of the collateral advantage and where that obligation is situated. Okay. So if there is no right to pay before the contractual date, if the contractual date is reasonable, then it has to be paid on that date. And you have Hired Management Services and FAI, which is a Queensland case of relatively recent times, where a covenant like that was upheld. Most mortgages, I must say, require payment by a specified date and not on a specified date, in which case, of course, the offer to redeem can be made early, and if the proper amount is tendered to redeem, a mortgagee is bound to accept it, subject to some compensation for foregone interest, providing it's not a penalty being paid. And that is, of course, the most common form of mortgage, repayment by a specified date. Okay.